Welcome, everyone. My name is Michael Sanambrogio. I'm the Dean of the College of Law here. And today it is my great pleasure to welcome back to the law school Judge Sean Cox, who is one of our distinguished alumni, a great American jurist, and a very good friend of the College of Law. And I'll have more to say about him in a moment, but I want to first thank everybody who helped put this event together and make it possible. Associate Dean David Blankfein-Tabachnik, who's our Associate Dean for Faculty and Intellectual Life. In our Dean Suite, Frank Aiello is our Chief of Staff. My assistant, Kelly Mell. Zach Almasian, who is this assistant to the Associate Deans. Our terrific marketing and communications department and IT department who have created this, who are making sure this is live streamed out all over the world. So others
That's
can
scary.
so others can share in this. So thank you, and thank all of you for coming today. A few just kind of ground rules. I think we have notes that note cards we circulated. Does anybody have note cards on there? No. Never mind. We'll have time for questions at the end, and if we get some note cards, you can put your questions on the note cards and pass them to the end. And so Dean Blankfein-Tabachnik might try to organize them in the interest of time at the end. Okay, so without further ado, our special guest today, Judge Sean Cox, served in the United States on the United States District Court for the Eastern District of Michigan from 2006 to 2025. And he was also the chief judge of the district court, and we'll talk about what that means, from 2022 to 2025. He previously served as a state court judge on the 3rd Judicial Court of Michigan from 96 to 2006. While on the bench, he was very prominent in solving some very important and protracted cases, including a protracted dispute that had gone back to 1977, which we'll talk a little bit more about, involving the Detroit Water and Sewerage Department, which ultimately resulted in the creation of the Great Lakes Water Authority. Prior to joining the bench, he was a partner at Cummings, McClory, Davis, and ACO from 1990 to 1996, where he was a trial lawyer, and he focused on municipal and personal injury litigation, including medical malpractice. So he retired from the bench in July, just this past July, and joined JAMS, which formerly was known as Judicial Arbitration and Mediation Services. He joined them as a mediator, an arbitrator, and a court-appointed neutral. JAMS, which was founded in 1979, is the world's largest provider of alternative dispute resolution services and handles more than 21,000 cases each year. He earned his undergraduate degree from the University of Michigan and, of course, his JD from Michigan State University College of Law, then known as the Detroit College of Law. So please join me in welcoming Judge Cox back to MSU.
Thank you. Thank you.
So as you know, we pride ourselves here on being an engine of opportunity. And we have a very high proportion of first-generation college students and law students who come to MSU and then go on to great legal careers. So I understand you were the first in your family to attend law school.
In college.
Yes. And before you went, you were working in construction and you worked on the assembly line at Ford. So tell me a little bit about that, and how did you decide to pursue a career as a lawyer?
I became interested in law through the Watergate hearings in the 1970s. And, Sam Ervin as the chair, Howard Baker, just great lawyers, Sam Dash, and I became enamored, kind of addicted to the hearings. I would watch him every day, and I was, a teenager. I think I was 15, 16 at that time, and I thought, wow, this is really interesting stuff. And of course, the hearings involved investigation of President Nixon by the Senate Judiciary Committee regarding the Watergate tapes and the break-in and different monies that were illegally exchanged. And so I became interested in law, interested in politics, and then I went to U of M, and towards the end, I wasn't sure what I really wanted to do, and I was looking at Ford Motor Company at that time in human relations, industrial relations, and I had 2 interviews, but then the automobile market dropped, and so I went back to work in construction, which is what I did to get myself through college, and I got laid off, and then that was in November, and Detroit College of Law was the only school that I knew of that had a January starting date or class. And so in December, I threw an application there, and I was accepted 2 or 3 days later. You know, amazingly, in those days, things moved pretty quick. And I started in the January class, so January 1980.
So I guess we need to start a January class again, basically.
Yeah.
That was our advantage. And then after law school, you went into private practice, and you excelled. You became a partner, which is many people's ambition to become a partner at a law firm, a prominent law firm. So at what point did you decide I want to take a turn and go onto the bench?
I'm going to step back.
Yeah.
Going back to law school.
Yeah.
First lawyer I ever met was my first day in law school, whatever the first professor was. So it was law, legal process was something very foreign to me. And for your first year students, maybe your second year students as well, law school was a big adjustment for me. It was a lot harder than I thought it was going to be. Undergrad was rather easy. And I wasn't really sure if that's what I really wanted to do. And it really wasn't until halfway through my second year, I got a job in a litigation law firm, and I really enjoyed the work. And my thought at that, I can do it. I can become a lawyer and excel. So that was kind of my evolution during the course of law school. Then I started practicing, and I really enjoyed it. It was medical and municipal law. But I was also very active in the bar associations and in politics. And at one time, I was number 4 person in the Republican Party here in the state. And I got a call from the governor's office in end of 1995. Jim Alexander, who became the chief judge of Oakland County eventually, and he said, "Would you be interested in becoming a Wayne County Circuit Court judge?" And wow, where did this come from? And I said, "Absolutely yes." And so that's how it kind of evolved. It was through bar association activities, working hard, getting a good reputation, getting to meet people, contacts, and then being active in Republican politics. We accomplished a lot, and when Jim called, I knew the call was right from Governor Engler, and so that's how I ended up being a judge.
So we talk about also here how's this audio set up? Is it a little too loud? Can we turn it down a little bit? We talk about here, the importance of beyond what you're doing in the classroom and the career, but kind of networking and developing your professional networks and mentors. And so it sounds like that's really key if you want to make a move like that, right? So it wasn't just your skill as a lawyer, it was also your reputation.
Yes. Yes. The law, like any other profession, it's not 9 to 5.
No.
To excel in the law demands time, and to take different steps, whether it's up in the legal profession, in a law firm, or even in government, or if you want to pursue a judicial path, you know, it's not 9 to 5. You got to go out there and you have to network. And if it's a law firm, you want to develop client base. If you want to be a judge, you got to go out in the community and do different, participate in different community events. And that's the path to growth in the legal profession.
Yeah. So, and then switching from the state court to the federal court, I imagine it was many of the same things, but how does that happen, that suddenly you're on the president's radar for a nomination?
Well, you develop a reputation in the legal profession, in the bar, and then it can be through the political party, one or the other, and you have developed contacts and a reputation. And what happened with me is I got active in politics at a young age, basically, and then as a young lawyer, and I helped out different individuals in campaigns and different young people like myself, and these individuals grew in the political arena. I helped out Candace Miller when she first ran for Secretary of State in '94. And then, of course, she went to Congress. Another congressman, a young congressman by the name of Thad McCotter. And when the vacancy popped up in 2004 regarding Judge Zatkoff's move to senior status, is that I didn't really have to apply. They said, we want you, you know, we know you. And so you have the political aspect of it, but also you go through the bar, through the legal profession, and you're interviewed by a committee of lawyers, and you're rated. And I was fortunate to get a good rating, and then your name is usually one of 3 submitted to the White House, and you have at least my colleagues, you have 1, maybe 2 interviews in the White House, which is totally cool. It's beautiful, in the West Wing. And then my final interview was with Alberto Gonzales, who was at that time White House counsel and later became the Attorney General. And it was interesting. His parents were also immigrants. They were actually migrant workers in the fields. And so we had a great connect. So that's kind of how the process is. And then the president submits your name to the Senate, and the ABA interviews you and does an extensive background check, FBI, and of course the Senate Judiciary Committee. So I got through it all.
You got a clean slate on the background check.
Long process, long process. Don't want to do it again.
So, oops. There we go. That's better. Sorry about that. So, was there anything that surprised you when you moved from the state bench to the federal bench?
The briefs were excellent, right? In state court, lots of times you had sloppy briefs, one-page briefs on significant issues. And then in the federal court, you have some of the best lawyers and legal minds writing the briefs and advocating. In the federal system, you have incredible resources. You know, you have at least 2 law clerks who are usually very, very, very bright to help you with your research and writing. You have 6th Circuit resources. You have this huge library with librarians there ready, you know, if you need any information on any subject, they're only too happy to get it for you. The resources in the federal judiciary are simply incredible. Now, one of my favorite stories is when I went from state court to federal court, is different lawyers would come up and ask me, aren't the federal court lawyers so much better than the state court lawyers? And I would look at them and say, no, that's not necessarily true. they look at me with this blank expression or this expression of shock. Because in state court, the lawyers litigate a lot more, okay? They try a lot more cases. In federal court, most of the attorneys that appear before you don't really have that experience. They may try 1 or 2 cases a year if they're lucky, and in state court, the litigators will try, 5, 10, 15 cases to jury in a year. So I found the state court practitioners, for the most part, quicker on their feet, better at trial, better at jury selection, better at openings and closings and cross. Whereas in federal court, the litigators, they knew the case a lot better. The briefings were excellent, and when you engaged them during oral argument, there was real engagement. There was real back and forth. So that was the adjustment that changed from state to federal court.
Yeah. Oh, that's really interesting. So we think of judges in general as presiding over trials, as listening to arguments and issuing opinions, but judges do a lot more than that, right? They actively push to resolve problems, solve problems, or problem solvers, and often bringing the parties together to create some kind of settlement without a formal trial or without a final decision. So tell us a little bit about that, and that might lead into some of the work that you did with the Detroit water issue. But how are judges, what are the let's focus on federal judges. What are the tools that federal judges have to kind of resolve problems outside of a trial and a judgment?
Well, in a large case, you don't really want to try too many cases that are going to take 2 months to try because they're complex. You do it, but if you can, you will really try to avoid those type of cases. And those type of cases, we will bring a scheduled day, 2 days, for a settlement conference, and we will order the parties, the decision makers, whether it could be GM or Google or whatever, to appear in a courtroom or in a conference room, and we'll work with the parties to negotiate a settlement. Sort of what happened with the big case involving the city of Detroit and the EPA that started in '77, as well as during the Detroit bankruptcy. And you work with the lawyers and you work with their clients, and you seek common ground. You try to settle the small parts of the case to build momentum, and which will a lot of times lead to settling the whole case, because once you got a few minor settlements, the parties have a stake in ultimately resolving the case. And so that's a tool that we use. Mediators, we will periodically bring in and help to resolve the case. I found that having the parties in court, knowing that I'm right next door, works a lot better than out of the courthouse. And that's one of the tools. I mean, of course, we have the tools of the schedule, okay? Sometimes you set a schedule, settlement conference before dispositive motions, or just afterwards, when the case is usually, once you've ruled on motions for summary disposition or summary judgment, everybody pretty much knows the lay of the land and how the case is going to proceed. So that's a couple tools that we use.
So tell us about the Great Lakes water case and how you, what was your involvement? So that went back to 1977. The Detroit Water Authority was sued over pollution, right? They were putting the sewage into the Detroit River. And then this was long before you were on the bench.
Right. I got the case in 2010. And this case has been going on and on and on. It was an incredibly costly piece of litigation for the city, okay? And prior judge was heavily involved in it from 1977 to 2010. And he had to retire then because of his age, and it was randomly assigned to me. It took me 6 weeks to go through the file, my career law clerk and I. And as we were going through the file, on top of that, we had the head of the criminal division and the special assistant in charge of the FBI paid me a visit and let me know that, hey, there's indictments coming down, and then, of course, of Kilpatrick and Bobby Ferguson, and, it's just what a crazy situation. And, the case had to end, okay? The case had to end. And judges, for the most part, are not administrators, right? We're not good at running government departments. That's not our background or our training. And this case had ballooned to where DWSD was paying thousands of dollars to consultants that weren't doing anything at all, you know? And then during the course of the litigation, 77 to 2010, one of the first things we did is we created an organizational chart for DWS, like, okay, who's the director, assistant directors, different department heads. When we created it, there were all these vacancies, positions that had not been filled. And I just said, this has got to end. Detroit needs to, take it over, or the state. And so basically, I told the parties this has to end, and a couple of them filed motions to dismiss because, a lot of these issues were moot. And I granted it, and then shortly thereafter, Detroit went into bankruptcy. And I was asked to mediate that part of the bankruptcy involving the Detroit Water and Sewer Department. I'll back up a little bit more. Millions of dollars in bribery money that Kilpatrick and Bobby Ferguson were involved in, the vast majority came from the Water and Sewer Department, the contracts for water and sewer work. And a little aside is that we still don't know how much money was stolen from DWSD during the course of Kilpatrick's tenure as mayor. So I turned down the role of mediator maybe 4 or 5 times, but eventually I said, okay, I'll do it. It was an incredible time. One of the advantages of being involved in politics is I knew some of the principals. I know Brooks Patterson for years. I knew Mike Duggan for years. I'd met Hackle, Ficano, Warren Evans, the different county execs. So I did have a relationship with them, and I went and met with them. I didn't order them into my court. I went and met with them because I know, politicians, political people really don't like judges. And some of you probably worked in Lansing, they kind of view judges as underworked and overpaid, right? And pompous, and maybe they're right on occasion. So, we had a conference, first conference, and I knew what they wanted, what they needed to get a deal done to create this water authority. And we met in my chambers on the 2nd floor at that time. Governor Schneider, who did an amazing job, and in my mind didn't get enough credit for resolving the bankruptcy, as well as a guy named Rich Baird. His name's been in the paper periodically about the Flint water issue, but Rich did a fantastic job getting the deal done for the Water and Sewer Department, and then the bankruptcy overall. But I'll give you a kind of a funny story. Our first meeting, there's tension in the room with all these political figures. And Brooks Patterson kind of tried to cut the tension. He told a joke. And if any of you knew Brooks Patterson one-on-one, he was hilarious, okay? And everyone cracked up. And for every meeting, Brooks would start off telling a joke. So we're always looking forward to what joke, as Brooke's going to tell us now. But we also broke the ice between the mayor, the city of Detroit, and Brooks Patterson, the Oakland County executive, because historically there always had been that tension between Wayne County and the city of Detroit and Oakland County. And so I knew something about both of them that neither one knew about themselves. Of course, Mike Duggan and I was in some of my classes in high school at Catholic Central, but I also knew that Brooks Patterson taught, before he went to law school, taught at Catholic Central High School for like a year. And I said, okay, Brooks, Mike, you know, you guys got something in common. And they look at me, they look at each other, and they go, what? And I said, Catholic Central. I said, Brooks, Mike, Brooks taught at Catholic Central. And I said, Brooks, Mike went to Catholic Central. It's like, they look at each other and said, Doug said, you taught at CC? And Brooks said, you went to CC? And it kind of really broke the ice between the two of them, and it kind of helped the process of, you know, finding common ground, which leads to resolution, and ultimately getting the deal done.
Yeah,
So, yeah.
that's great. And you're still using those skills today in your new role, which we'll talk
Hopefully,
about
yeah.
in a minute. So you were chief judge of the court for 3 years, and I don't know that all of our students know what a chief judge of a federal district court does. So can you say a little bit about that?
The Eastern District of Michigan is actually one of the largest districts in the United States. And the chief judge is responsible for, you know, the administration of the court in the Eastern District of Michigan, which is, you know, the east side of the state of Michigan up to the bridge. And there's 5 courthouses. There's 320 employees, and you have usually 21 judges plus their staff that you have to take care of. The chief judge pretty much has absolute say over the administrative side of the court. Each of the judges is independent within their own chambers, but as to administrative issues, budget issues in particular, that's the bailiwick of the chief judge. And so you're dealing with all the HR issues, which you have to deal with as well.
Why are you looking at me?
You got to deal with the judges like you have to deal with the law professors, right? So, and then also, you're on the Judicial Council of the Sixth Circuit, which is a policy-making body for the Sixth Circuit, all the courts in the Sixth Circuit. And then you're also drawn to D.C. for different types of administrative issues. So that's kind of it in a nutshell.
Did you like doing that?
Actually, for the most part, I did.
Yeah.
Because maybe as a dean, or once if you've been involved in an institution for a period of time, you have certain ideas as to how the institution can run better. And of course, as a chief judge, you have that opportunity to effectuate change. And also at the Sixth Circuit level, you know, I think during the course of my tenure in the Sixth Circuit, we took real positive steps to make judges more accountable. In the state system, the judges do have accountability through the State Court Administrative Office. There's guidelines. In the federal system, it doesn't work like that. The only way they can get rid of us is impeachment, right, and conviction. So we took steps to make our judges more accountable. And one of the other things we did is we got our courts reopened, okay? And to where, you know, motions are, for the most part, are in the courthouse in person.
Coming out of the pandemic,
Yes.
because they had been closed.
Yeah, we were really shut down, one of the most shut down districts in the United States. And so we were able to get that done in a really good way. And one of the things we did is we looked around at other districts throughout the United States and learned how they were. This is, you know, March 2022. February of 2022, we were still pretty shut down. and we looked to see what districts around the country were doing. And if some of you might recall, is the city of Detroit was extremely advanced in opening up their facilities to the public. And one of the things I did is I had lunch with the mayor, and I said, Mike, you know, you guys have this reputation of being, you know, way ahead of any governmental agencies in opening up. And so I'm talking, and all of a sudden he starts texting. And he said, you know, it's not my credit. You know, I don't deserve the credit. It's Dr. Rob Dunn, who was a ER emergency, ER infectious disease and epidemiologist at the medical center, who kind of devised the whole plan for the city of Detroit. And we had a recon committee of about 7 or 8 judges to you know, get us through the reopening process. And we put Dr. Dunn right there on our committee, and he was the ones, you know, he came up with, you know, safest scientific-based methods of opening our courts. So anyway,
Great.
yeah.
So speaking of accountability of federal judges, as you mentioned, it's they serve life tenure.
Right.
Can't reduce the salary, so even now during the shutdown,
We get paid.
constitutionally required to be paid, right? Not everybody at the court, but the federal judges, right? It's
Right.
it's
Well,
a mix.
you know, there's a reserve currently.
Yeah,
You
yeah.
know, in the judiciary,
Yeah.
that will eventually run out too.
So some judges retire from the bench, such as yourself.
Right.
But many do not. The average age now for federal, I think it's for a federal district judge, is 69.
Right.
There's a 100-year-old federal judge. There's a 97-year-old.
I think they're out of the Southern District of New York, at least one of them.
I think they're in the east.
Okay,
Yeah,
yeah.
somewhere. I think it might be New York or New Jersey. How do we make sure that these judges continue to maintain their kind of competency when they're, as you say, impeachment is the only thing, and it's probably impossible to do that.
Right. You know, to get a judge that, you know, possibly is not really able to perform like he or she used to step down or go to an adjusted docket where maybe they're not trying cases or handling complicated cases, is very difficult. It's very difficult, and it's a challenge, and it is something chief judges hate at all levels. But when you have lifetime tenure, it's also going to be an issue, right? So,
Do you think we should change the Constitution if it were possible? What do you think about term limits for federal judges?
I don't like the word term limits.
Okay.
Is it something that we can look at? Yes. Okay. Because federal judges, I mean, we deal with incredibly significant cases for society. We have, you know, multi-million-dollar lawsuits between businesses, and our decisions affect not only the stockholders or the lawyers involved or the corporate boards, but also the people that work, you know, for those corporations that have families and are living paycheck to paycheck. So the work is significantly important and has, you know, great impact on the community. So, you know, it's an issue that should be explored, but how it's explored, I don't know, you know, so.
No.
I punted on that one, right?
Okay, okay. All right, well, here's another one. So, important issues, absolutely, right? You mentioned that federal courts resolve, and I think right now, um, whatever one thinks of the current administration politically, I think everybody agrees they're testing the limits of executive power, probably like no time since the first Trump administration, which it also tested, but I would say probably not quite as much.
But also,
You know,
President Biden did as well.
yeah, it's been a growing, I think it's been a growing trend really since Clinton, really, in particular.
Yeah, it is. I mean, there's a whole debate is that about the expansion of executive power, you know, since the 50s, in particular the 60s, and you know the tension between Congress, the tension between the executive and the judiciary is not anything new in our history. As some may recall, there was a lot of tension between probably our greatest Chief Justice, Marshall, and President Jackson, right, Andrew Jackson. There was a lot of tension between the Supreme Court and President Lincoln during the Civil War. And then, of course, Theodore Roosevelt and the Supreme Court during his time as, you know, a progressive president. And, you know, FDR. And, you know, the FDR kind of went nuclear when his, you know, favorite pieces of legislation were declared unconstitutional by the Supreme Court in his first term. And, you know, he wanted to pack the court, expand the court, and both Republicans and and Democrats in the Senate said no way, and he had to back out. So this tension, some of this tension that we are seeing here today, and we've seen since, you know, probably the last 12 years, is nothing new for our country. So we'll get through it.
Okay. How do you think the federal courts are doing at this time with the kind of stresses? Because they have to rule, and the district courts are, you know, usually the first forum for questions about separation of powers.
Right.
You know, if the executive is overstepping with Congress, due process issues. One particular tool that the courts had for a while was these nationwide injunctions, which the Supreme Court cut back on just in July in CASA. So these were nationwide injunctions where a district court will issue an injunction which affects more than just the plaintiffs to the suit, right? So examples of this might be during the Biden administration, vaccine policies; during the Trump administration, immigration policies. In this particular case, it was birthright citizenship.
Right.
And there's been a lot of critics from both the left and the right of these nationwide injunctions for a while. They are typically, well, they lead to forum shopping, right?
Absolutely.
All of the lawsuits against the Biden administration originated in Texas, and the lawsuits against the first Trump administration originated mostly in California. Now I'm not sure it's all California, but
Washington.
Washington,
Out
yeah,
east,
yeah. So, but it is a powerful tool, right? And then on the flip side, if you can't enforce this policy against one, let's say take an immigration example, one immigrant here, you can still enforce it in another area if there's not a nationwide injunction. So, do you have any thoughts about that? Is that hamstringing the courts by eliminating those? How do you think that's going to play out?
There's fundamental problems with having nationwide injunctions, especially where you have a special interest, which is occurring, selecting a particular forum to bring the lawsuit and seek that type of relief. it's something maybe Congress needs to resolve. If they would resolve it, I don't, maybe, probably not. But it's something that the Supreme Court has to work through, and I think they are working through. This development and this approach and what's going on now is really new. And I think the Supreme Court is really trying to get its arms around the issue. And, you know, as a district court judge, you know, you're going to follow the law, or supposed to follow the law. And so, I mean, injunctive relief, in particular TROs, are rare, okay? In the course of my career, maybe you know, almost 20 years on the federal bench, maybe I granted 3 or 4, okay? And so the TRO and of course this nationwide injunctive relief is something that should be very, very, very rare.
Did you ever issue a nationwide?
No.
Did you ever get a request for one?
I don't remember.
Yeah.
I don't remember. But again, this type of relief has to be, it should be incredibly rare, but that's not the case today, or been the case for the last several years. So it's something that needs to be addressed.
Yeah, yeah. I mean, they have really exploded.
No matter, you know, whichever side of the fence you're on, it's just, it needs to be resolved.
Yeah. yeah.
In terms of your politics.
So another thing that's grown with nationwide injunctions, although I don't know that that's related, but is the use of the emergency docket by the Supreme Court to resolve cases, which used to be, you know, kind of urgent procedural matters, death penalty stays, requests for stays of execution, things like that. So unlike the merits docket, right, the emergency docket, usually the opinions are issued without full briefing, without oral arguments, and very little and sometimes no reasoning by the court. So this is something that's also kind of been growing even before this current administration, but I would say within the last decade it's been growing, in the last 5 years exponentially. So, and you know, there's a question about what the precedential value of this is. As you say, as a federal district judge, you want to follow the law. There was a federal district judge who was in Massachusetts who was reprimanded by 2 of the justices for not following a decision in an emergency docket case, and he said, "I didn't know this was precedent, so I stand corrected and I apologize to the court." But it's a lot harder, right, to try to figure out the law when you have a very limited opinion from like an emergency docket case, as typically we have.
So my thought is,
Yeah.
you know, follow what the law is, make a decision. Judges are paid to make decisions, especially trial judges. And then if one party wants to take you up, you know, let them take you up to the appellate court or the Supreme Court level. For me, I never really worried too much about being reversed, all right? I think I had a rather low rate because we pretty much, you know, stuck to what the law is, just called balls and strikes, right? So the trial judge, which is what I did, just make a decision. You know, best decision, your best reasoned decision. And if you get reversed on something so uncertain, some, you know, new way of how the Supreme Court's dealing with hot topic issues, you know, just make a decision and don't worry about it. So, you know, a lot of this, what the Supreme Court is seeing today and has been seeing, is kind of because of the breakdown of the political system, right? Where parties are either way over here or way over there, and they don't talk to each other, so they're running to court much more now than they ever did before to resolve, you know, what seem to be our political issues.
Right, right. So let me ask you a little bit about your clerks and how you use your clerks, because I know we have students who are interested in clerking at either state or federal level, and you know it's a great experience. It's very competitive. It opens up lots of doors. So maybe tell us how your clerks work and kind of what are the benefits of going into clerkship as a start to your professional career.
The benefit is my term law clerks were 2 years. Usually takes them 8, 9 months to figure out what's going on. And then by the end of the second year, they really understand the most common federal issues that courts see. And also developed really good writing skills because of the other clerks that are available to them, in my case, a career law clerk. So when you go to a law firm, you're going to have partners asking you what the law is on these federal issues and asking you to draft the briefs because you know the law cold, and plus you know kind of how federal judges approach issues. And the other, you know, if you're a federal clerk or a trial court judge's clerk, you know, with jury trials, after the verdict, you're back in there talking to jurors just like me and getting insight into what the jurors found significant or not significant in a case or in a presentation. So it makes you very, very, very marketable. You don't have to be in the top of your class, okay? Judges, I'll point to the different Eastern District of Michigan. I only hired from Michigan law schools, okay? Because any law clerk that I brought on board and we trained is I wanted that law clerk to stay in the Eastern District of Michigan or in Michigan to be part of our legal community and contribute. With me, you didn't need to be in the top 5% of your class or whatever. My process was we would post to the local law schools and as well as Oscar, and we get all these resumes in. My law clerks would go through and select the top 10 in their mind that they would want to interview. But I also went through every single one of the resumes that were sent to me, and sometimes I would add or subtract from the pile because of what I saw. And then we bring in 3, we interview 10, maybe 11, 12, bring in a final 3 or 4, and from the final 3 or 4, then we would select the individual candidate. When you're applying for clerkships, know the judge you're applying to, know their background, know what law school they went to, their likes and dislikes. I told the dean that I never had and never would hire a law clerk from the East Coast that went to an Ivy League school. Because as soon as that individual get done with his clerkship, he or she's heading back east, or they're looking to, to go the circuit route. Another tip is on your resume, have something unique, something different than the other candidates, okay? And before you start the interview process, find out, don't contact the judge's current law clerks, but contact the judge's past law clerks. And what does the judge like? What does the law clerk like? What's the interview process like in the chambers? Because chambers are different. And so I also was impressed when I found out that an individual applying for clerkship with us, went out and contacted my former law clerks, because that was also positive with me. So those are some thoughts.
Doing their research.
Doing the research.
That's right. That's right. That's a really helpful advice. Yeah, I remember when I interviewed for clerk, I talked to former clerks, and my judge, they said, he's going to ask you about this opinion and your opinion on it. So I was like, okay, I prepared for that opinion,
Yeah.
which is a little idiosyncratic, but that was his approach. Well, I want to make sure we have some time for questions from the audience. So let me just pause here to see if you have received anything, or if anybody has any questions they want to ask. Oh, we have some. Okay. Yes.
Well, this would pivot a little bit. There's one here. Are there others?
There's more coming down.
This is an interesting one. How would you recommend that judges be made more accountable while retaining their independence? You, of course, spoke a little bit to accountability and the question on which you punted, but what might you further?
Apparently, we're coming back to it.
So the question is, how do you make judges more accountable, but yet retain their?
While retaining their independence. So
I think it's kind of a separate issue.
yeah.
Okay. Accountable means moving your docket, don't letting cases languish for a year or 2 or 10 years without making a decision. In the state court system, you can't, because you have guidelines. And if you don't meet the guidelines on the criminal side or the civil side, the state court administrator's office, which works for the Michigan Supreme Court, they will contact you. And if you don't meet the guidelines, you can actually be removed from the bench, which I think most of you know. In the federal system, that does not exist. So it's not really, it's something very uncommon, but you have judges that can take 2 or 3 years to make a decision on a motion for summary judgment. And the case is languishing, and you have, major corporations, they can't move. They can't move forward because of inaction. So that's what I mean by accountable. Judicial independence is, in my mind, a separate issue.
Do you think that judicial independence is sound right now? Or do you think judges, even in this very highly politicized environment, feel safe and able to make the decisions they think are the right decisions?
I would say absolutely.
Yeah.
Absolutely. The noise doesn't really affect the issue of independence.
Yeah.
And I know that from the members of my own court.
This is a question contrasting again distinctions between federal and state judges. I've heard that some federal judges expressed disapproval over the rigidity of federal sentencing guidelines, having served as a state and federal judge. Do you have any thoughts on the guidelines and whether they're serving their purpose?
The guidelines, when the guidelines were developed, it was a real step forward in sentencing, okay? For the most part, federal sentencing is a lot harsher, maybe that's a better term, than state court. And particularly for certain types of crimes. The guidelines are working, and I think the guidelines, the people involved, the individuals involved with preparing, developing guidelines and having the guidelines adopted, really look at it and study the issue. And one of the reasons for guidelines is consistency throughout the United States in terms of A, commits his crime in state B, his sentence is going to be comparable for C, committing the same crime in state D. So, the guidelines work. The guidelines work, but the sentencing is fundamentally different in the federal system versus the state system. The state system has guidelines, but they're not structured like the federal system. I don't know, did I answer the question for the
Sure thing. Do the administrative responsibilities as Chief Justice, due to the administrative responsibilities as Chief Justice, how limited was your time on the bench and overseeing cases?
You got an elevation.
So, I made a mistake initially when I became chief judge. I didn't take a reduced docket. In most other districts, they do, okay? And so that added a lot of time onto my work week, okay? Did it affect the quality of my work product as a judge? I don't think so, you know. But now, I mean, after like a year and a half, I said, no, I got to reduce my docket, and I did. And the current chief judge, Steve Murphy, also has reduced his docket, and I think that trend, you know, is going to make it more manageable. You know, full docket and being the chief judge of a large court, there's a lot on your plate, especially on the administrative side that you just haven't seen before.
Great. So one last question, then I want to let you have the last remarks on anything else you want to share. But so just asking about this last move that you've made, stepping down from the bench, of course, a job guaranteed for life, guaranteed salary for life, and going to JAMS. So why, and younger than the median age of a federal judge. So what made you decide to make this move now, and why JAMS?
So, I mean, within a year or two, when I became a district judge, you know, there were issues with judges staying too long, okay? And I made a commitment to myself that I was not going to stay too long. Being a trial judge is very demanding, not only mentally but also physically. Court of Appeals, with all due respect, they have 8 months a year. They're in session 3 or 4 days per month, and they're not back and forth in and out of a courtroom. They aren't managing a trial, and managing a trial is very, very demanding, especially a complex case. It's demanding mentally, but it's also demanding physically because you're beat. You're tired, and if you're tired, you know, you can make the wrong decision. You know what I mean? So I wanted to be, quote unquote, at the top of my game when I left. So I just turned 68 in September. A lot of people retired at 68, right? A lot of lawyers are, and I made up my mind that I was going to go sometime between 70 and no later than 75. And this opportunity presented. You know, my life's changed over the last 5 years. I got 8 years. I got, you know, 2 of my daughters are married now, and my son. I got 2 little grandsons in Chicago, and my other daughter's having a baby in November. And my wife retired 4 years ago, and so she wanted me around, amazingly. So it was just those factors that went into it. And I had already done everything that I could do as a judge for the most part, right? I served in the Court of Appeals, you know, the Sixth Circuit. I was a chief judge. There really was nothing left for me to do. And then why not turn the seat over, hopefully, to a much younger version of myself. So that was the thought process.
So leading by example.
We'll see.
Right. Any final remarks you want to share with our students who are preparing to embark on their legal careers?
So the legal profession is a wonderful profession. It gives you so many opportunities, whether it's government, public service, being a lawyer in a law firm, making a difference there, or the judiciary. I'm just so fortunate that this is what I ended up doing. It's been incredibly rewarding. I obviously exceeded my expectations. Believe me, I never thought of being a judge when I was in law school here. All I wanted was a job when I got out. But there's a couple things about the law. It's not a sprint. It's a marathon race. And to succeed in the law, you've got to do it day in and day out. It's not the brightest individuals in your law school class that will have the most successful careers. It's the individual who works hard, does the right thing, does the ethical thing day in and day out. And those are the individuals that succeed in our profession. It's not the sprinter. It's kind of the tortoise to an extent. And, you know, it's been a wonderful ride. I'm moving into the next stage, but it's been good. So just work hard, do it day in and day out, and you're going to have a very satisfying career. Again, it's not 9 to 5. It may be 9 to 5 down the road, but it's a demanding profession. It can be incredibly stressful, but at the end of the day, it can be incredibly rewarding. So thank you.
Right. Thank you so much. Thank you for joining us.